So this is about the fact that certain jurisdictions are unwilling to share information about the accounts that they have. And I actually think you could take a slightly positive view of this. And the positive view is that the ultra wealthy in the United States actually weren't in this week. So the ultra wealthy in the United States weren't using these hidden accounts, and or at least we don't know that they were using these hidden accounts. And one reason for that is actually US laws. So the United States in the last 15 years has actually dramatically changed its focus on secrecy, and it's made it much, much harder for US citizens and US taxpayers to hide accounts the way they used to. This all started off with Switzerland. Switzerland used to be a location for hidden accounts, and the US brought criminal charges against Swiss banks, and Switzerland is no longer a location for US accounts. And we can talk more about this, but I actually think that should give some listeners some hope that it's possible to address these concerns by changing laws that allow secrecy and by requiring reporting of domestic taxpayers.
Lillian, is there as much incentive for the ultra wealthy in the US to hide money? When we look at our own tax code, are they fairly well protected, even if they're not hiding it in offshore accounts?
Okay, so we all know we're being recorded, so be careful what you say. Well, good morning, everyone, and thanks. We are on day 4 of our 5-week class. A couple quick housekeeping matters. I did not send out any slides this morning, so if you did not get them, that's correct. I did not send them out. I am going to use a few slides this week, and I will clean them up a bit and send them out before next week's class in case you really are interested. Much of what I'm going to show you today is stuff that I don't think you will ever want to look at again in your life. So I'm going to get rid of those slides before next week. Last housekeeping matter, next week is our last week, and our topic's going to be alternatives to the American civil trial system, court system. And in that regard, I mentioned earlier that there is a movie out on Netflix called Worth, W-O-R-T-H, and it discusses an alternative. And it also addresses a question that we looked at in week 1. I believe it was week 1, when we tried to figure out the damages in the case like ours. So how do you assess damages when someone's been injured, or as in the video from Worth, it has died as a result of the, in that case, crime. So if you have a chance to watch that, fine. If you don't, that's okay. You don't need to, but I just want that reminder. The last housekeeping matter is on the outline that I sent for week 1, that we used weeks 1 and 2, at the very end, there are 2 quotes. I want to return to those 2 quotes next week. One of the quotes is from former Chief Justice Warren Burger, and it basically says that the purpose of a justice system is to provide people with a resolution as quickly, effectively, and with as little time as possible. The other quote is from a man, I believe by the name of Davis. Now I'm blanking on his name. From Owen Fisk, professor at Yale, who says that the purpose of a justice system is to bring us closer to our constitutional and democratic principles, and that getting peace by settlement is not what we want. We want actually court rulings to help us come closer. I want you to think about those 2 quotes. If you still have that page, that original handout, take a look at them. They're at the end. I will send them out next week with the Zoom link so you can think about them again. But what is the purpose of our justice system? Is it to provide a resolution as quickly as possible with the least amount of cost? Or is it to take the time necessary and the cost necessary in order to give meaning to our constitutional principles? So rather philosophical, but we'll, even at 9:30 in the morning, we can be a little philosophical. Okay. Last week, I left you with a quiz question. I left you with this question to think about. Who is in charge, or what position is in charge of the courthouse? And I define being in charge as the person who gets to close it down in case of a ice storm, snowstorm, that sort of thing. And we have a couple votes. We have votes for sheriff, chief judge, county clerk. And the winner is sheriff. And that is by statute. So one of the Illinois statutes tells us that the person in charge of the courthouse is the sheriff. So that brings me to the topic of the morning, which is let's look at some of the people, some of the positions that are necessary for a trial to take place. And one of those positions is security, and that's the sheriff. So the sheriff has to unlock the door or have someone unlock the door, but also is in charge of security for the courthouse. And that includes the bailiffs in the courtroom and the bailiffs that are assigned to jurors. I'm not going to belabor that point. I think you get it, but I am going to ask you this. Let's just test our civic knowledge this morning. So again, you can use chat. So for those of you in Jackson County, who is the sheriff right now? So Jackson County, who's the sheriff? Williamson County, who's the sheriff? Let's just see how up we are, how current we are on our knowledge of county officials. So who's the sheriff in Jackson County? Who's the sheriff?
Burns.
Who's the sheriff in Williamson County? And yes,
Burns.
Bob Burns is the sheriff in Jackson County. Any votes for who's the sheriff in Williamson County? Those are the only two counties that I'm going to include this morning. Well, it is Benny Vick. So Benny Vick is the sheriff, a longtime sheriff, I think, in Williamson County, and Bob Burns here. All right, so that's one of the people that we need in order to have a trial. We also need the circuit clerk. And here I want to take a minute and help us get clear on something, because my suspicion is that many of you get confused between the circuit clerk and the county clerk. They both act sort of as secretaries. And I mean secretary in the best, fullest sense. Assistants, managers of the system, keepers of the records. But think of it this way: the county clerk is the clerk or secretary manager for the county. The circuit clerk is the assistant secretary manager administrator for the circuit court. So if you link those two words, I think it helps. County clerk, the county, that's the person who takes care of voting, takes care of all the vital statistics. The circuit clerk is for the court. And yes, someone has added in chat that the current county clerk is Frank Bird in Jackson County. Now here's my question: who's the circuit clerk? Who's the circuit clerk for Jackson County? And for those of you from Marion or that area, who's the circuit clerk for Williamson County? So let's just see how good we are. Circuit clerk for Jackson County, weigh in on chat, and the circuit clerk for Williamson County. Weigh in on chat. We're not getting a lot of responses here. Circuit clerk for Jackson County, circuit clerk for Williamson County.
Cindy Savanda.
That is correct. Cindy Savanda is the circuit clerk for Jackson County, and for Williamson County, it is Justin Maze, M-A-Z-E. Now, Why is that person important? Well, if you went over to the courthouse and there was a trial taking place in person, the circuit clerk is the person sitting next to the judge, handing the judge files, taking orders from the judge. The circuit clerk's office has evolved over time into a very busy office. So for the purposes of what we're talking about, a civil trial, that's the person who's going to, that's the place you will have gone to file everything. So even today with e-filing, it is through the circuit clerk's office that you file. All the records of everything that took place in the case, all the motions, all the orders that the judge issued, all the subpoenas that were issued, all that is going through the circuit clerk's office. The circuit clerk will be in the courtroom, will gather up any evidence, will gather up the jury instructions in a case like ours, and will put all that together in the file for the trial. So when the case were to go on appeal, all of that has been collected by the circuit clerk and is ready to go to the court, to the appellate court. The circuit clerk sends out notices. So the judge may say, set this for trial on X date. And the clerk will be the person who sends out those notices. More and more that's being done electronically, but it's the circuit clerk who's going to do it. Couple other things that you may not think about. In the case of a divorce, it is the circuit clerk's job to send off that divorce order to the Illinois Department of Vital Records so that the vital records are updated. In the case of a protective order being issued, it is the circuit clerk's job to send that off to law enforcement so that the law enforcement personnel know that there's been a protective order issued. So if someone calls 911 and says the person who's not supposed to be in my house is outside my house trying to get in, the police know that there's a protective order that's been issued. The circuit clerk's office also collects fines and fees, traffic fines, for example, but also collects child support. So over the years, people would go to court and say, my ex-husband, because typically it was the man, is not paying child support. And he would come in and say, oh, yes, I have. Look at all these canceled checks. I've paid the child support. And there'd be an argument as to the validity of all that. And so for many people today, the child support payments are made to the circuit clerk's office, who then dispenses the money to the parent who's supposed to get the child support. It's a way of ensuring that there's a good record of who's paid what. So that's a circuit clerk. For our purposes, it's the person who's sitting next to the judge, keeping all the documents together that belong in the file and sending out all the orders or notices that the judge sends off. But I thought it was interesting for you to think a little bit bigger than that to some of the other aspects, which means at election time, I know it's always very hard to think about, well, what questions do I ask a circuit clerk candidate? And basically, you want to make sure that it's a person who's responsible, who is able to manage, and is able to hire people who are good managers and will be responsible, discreet. They see a lot, they know a lot, and also impartial, not going to hide documents from one side or another. I will tell you one very quick story. Many years ago, when I was with the Attorney General's office, the Attorney General for the state of Illinois, one thing we would do is accompany the state bank commissioner when the state bank commissioner closed a bank. Now, most banks in Illinois are federally chartered, but there are some that are state chartered. And it's the job of the state bank and trust commissioner on occasion to close a bank because it's running out of money. Yeah, it's a good reason to close a bank. It's running out of money. So in one particular case, we were going to a county, and you try to do this very discreetly. You call the judge in advance and tell the judge that you're going to be there on an emergency matter. You need to see the judge at X time. In this particular county, for whatever reason, when we got there, the judge was tied up on the bench. We could not get to him. So we wound up having to go to the circuit clerk's office and file the papers to close the bank a few minutes before 3. The bank closed at 3. And we had to walk in, get to it was a small county. We asked for the clerk herself, and we handed her the documents, and we said, it's very important that you not call anyone or tell anyone. We just need you to file this. We're going upstairs to see the judge as soon as he's free from the bench. And she looked down at the documents and her eyes got very big. And she said, okay. And so far as we know, she honored that. But the last account of any size in that bank had been the local church, and it had withdrawn the money the day before. And that was the last movement action that came about the bank being closed. That's a very interesting procedure, closing a state bank. In almost every case, they try to get the bank sold that night so it can reopen tomorrow with new ownership. In this particular case, it took a few days, but the interesting thing was we had to walk in and have the clerk, just for reasons of logistics, because the timing was not working out as we liked it to work out. We had to ask the clerk to file it a few minutes before 3 when the bank closed, and we did not want anyone else with advance notice. So that's the circuit clerk. And you will remember the difference between the circuit clerk and the county clerk. And by the way, we elect them both. We elect them both. So who else do we need in the courtroom? Well, we need a court reporter. Now, at one time in history, in the first trial I ever, take that back. Oh yeah, the first trial I ever tried, the first case I ever tried in court, in jury trial, the court reporter took down by hand, the old stenographer by hand. Then we moved to those stenographic machines. Now we've got computerized stenographic machines, and I don't even know what they do, but they're much improved, but we still need someone doing them. And in some courthouses, they use an audio system rather than a court reporter. But at some point in time, the court reporter has to transcribe from the tape to paper if the matter is going to go on appeal. So the court reporters are appointed by the chief judge of the circuit. So not in the county, but throughout the entire circuit. So we're in the First Circuit. There are 9 counties in the First Circuit, and there is a chief judge over all those 9 counties. And if my memory serves currently, it is Bill Thurston, who is the chief judge, and he would appoint the court reporters. They have to pass a test. They take an oath to do their job responsibly and without bias to anyone. Anybody who's been in a courtroom for a jury trial may have seen a moment when the court reporter looked up at the judge and gave some sort of signal or even interrupted the judge, and that meant that she or he, there are some male court reporters, have just run out of paper and has to change the paper in the machine. So that person's essential to getting everything down. And if paper goes out, you got to replace it. Not everything at the courthouse is recorded. Traffic, I doubt if it is. A criminal plea would certainly be, and a civil jury trial or a criminal jury trial or any other civil matter where the attorneys think there's going to be a possibility of appeal and they want to argue a motion, they would ask for a court reporter. So that's the court reporter. What about language interpreters? And you may be a little bit surprised to learn that by court rule in Illinois, so this is an Illinois court reporter, in every matter, civil or criminal, for which there is someone whose language is not English or who is deaf or hearing impaired, there must be an interpreter. And that is for the people who are the litigants, but also witnesses, victims, jurors, or anyone who has an interest in the proceeding. So in a divorce case would be the 2 people who are married. In a case like ours, there was a car accident, it would certainly be you, the person who got injured, and the other guy, the person who injured you, but it might be a witness or it might be a juror. So there must be an interpreter. Now, as you can imagine, in Cook County, there's probably umpteen interpreters for various languages. In Jackson County, not so much. Jackson County now has Spanish court. Once a month, Jackson County brings in a court reporter who's certified and who takes down, who does the interpretation for matters for those people who are primarily Spanish speaking. If something comes up in between, they reset it for Spanish court day, like I said, once a month. For other languages, they use a Zoom interpreter. So one of the things we've learned through this pandemic is some of the wonders of Zoom. We've also learned how much we hate Zoom and get tired of Zoom. But here's an instance where it's worked quite well, and they can bring in interpreters for other languages through Zoom. And as you can imagine, because of our international student population and our many medical personnel and professors who come from various places around the world, we periodically need all sorts of language interpreters. The Illinois Supreme Court has a process by which they are certified to make sure that they know the language and are sworn to render it, I'm looking for the words here, truly and impartially. Now, any interpreter will tell you that one of the problems of translating legalese, words that we use, from English into whatever language is sometimes a real challenge. But they take an oath and they have been tested, certified. So in some way they've been tested for their familiarity with the language. I don't know if Union County has a Spanish court day. There's certainly going to be a lot of folks in Union County that are primarily Spanish speaking, but I just don't know. So we've talked about the sheriff who opens the courthouse door and provides security. We've talked about the circuit clerk who keeps all the records. We've talked about the court reporter who transcribes everything that goes on in the courtroom. The language interpreter where that is needed in order to make sure that everyone can participate fully. Now we're down to the jurors. The jury that we would be using in our case, in a car accident case, is called a petit, P-E-T-I-T, petit juror. P-E-T-I-T, petit, means small. What's the difference? A grand juror, grand, G-R-A-N-D, juror, is one who is called by the sheriff, by the state's attorney to investigate and decide whether or not to bring charges. Why do we call one petit and one grand? Because there are more people in a grand jury. There are only 6 or 12 on a petit jury. So the word petit does not mean lesser. It means, hey, it's smaller in number than a grand jury, which I believe is 23. So we're going to have a little quiz here. And I want you to use just the reactions button. So find the reactions button, and there's a green check for yes and a red X for no. So I'm going to ask you if the following people should be on a juror in Illinois. So should women be on a jury in Illinois? Yes or no? Should women be on a jury in Illinois? RJ smiling because he thinks that this is a setup question. Anyone say no? Okay, everybody who's voted says yes. Well, this gives me a chance to tell you another story. For some reason, there are people that think that murdering your spouse is a better way to divorce than going to court and divorcing your spouse. So there was a woman in Georgia who wanted to get rid of her husband. So she hired a hit person to kill her husband. Apparently they weren't very good at it, and they both get detected and found out and arrested. And this is some years ago in Georgia. He goes to trial first, is convicted, is sentenced to death. She goes to trial next, is convicted and sentenced to death. They both file the usual appeals. They both lose. execution is in the foreseeable future. She then raises the question, wait a minute, I'm entitled under the US Constitution to a jury of my peers. And there were no women on my jury. So it was not a jury of my peers. Goes to the US Supreme Court that says she's right. They void the conviction, they void the execution, obviously. She is retried, and at that point, she is sentenced to life in prison. In the meantime, the hitman is executed. Interesting scenario as to how things worked out there that way. But I'm not going to share with you something that I will bet you 90% of the lawyers in Jackson County do not know. I just told you that that case was based on the 7th Amendment to the US Constitution that gives you the right to a jury trial in certain matters. That is one of the very few, if not only, parts of the Bill of Rights that does not apply to a state. For some reason, the jury provision, it does not apply to the state. Most of the Bill of Rights, First Amendment, religion, petition, speech. Fourth Amendment, you can't come and arrest me unless you have reasonable cause. You can't search my house unless you have reasonable. For some reason, all of those apply to the states as well as the federal government. But the 7th Amendment, not so. But don't worry, in Illinois, we have a jury provision. The Illinois Constitution provides for trial by jury. Okay, so thank you for participating in my setup so I could tell you that little story. How about someone who is blind? Should someone who is blind be allowed to serve on a jury? So yes, green, no, red. Should someone who's blind be permitted to participate in a jury? I'm seeing no no's, a number of yeses. Some folks are not voting. It's okay, you don't have to vote. All right, well, yes, of course.
Yes.
And we would make some kind of accommodation. RJ, do me a favor and check out which amendment I meant, please.
Which what?
I'm asking RJ to check something for me. And Dennis weighs in by reminding us that justice is blind. So of course we would allow jurors who are blind. How about nursing mothers? Should nursing mothers be allowed to be jurors? Should nursing mothers be allowed to be jurors? Again, weigh in with green for yes, red for no. Well, you're going to be shocked to find out that nursing mothers by statute are excused from jury duty. In Illinois, a nursing mother is excused from jury duty. Doesn't mean she can't be, but she's excused. I don't know why. I looked at the statute. It's a relatively recent statute. I will tell you that as a few years ago, the Illinois Supreme Court asked all the courtrooms around the state to have a room for nursing mothers, and Jackson County does indeed do that. All right, how about this question? How about persons over the age of 80? Should persons over the age of 80 be on the jury, or should we just excuse them because, well, you know, getting a little old? Okay, so everybody who's weighing in is saying yes, but I'm seeing one no. Well, right now in Illinois, they could be. They could also be excused if the court found that they simply could not participate, or they could ask to be excused if they have a hardship, and I'll tell you what that is in just a second. All right, one last quiz question for you. How about persons who were convicted of a crime, have served their time, or paid the penalty, whatever it might have been, and now are free and living within our communities? Should a convicted felon be able to serve on a jury? Red, no. Green, yes. Well, I think I saw 2 no's. They could. Now, I would think that if this was a criminal case, one of the things you would do is ask if anyone had experience in the jury, in the criminal justice system, and you might, they might be excused for cause, depending, or one of the lawyers might excuse them depending upon their responses. So you might be interested in whether or not, or how we get jurors. And I looked it up. And here's how we get jurors in Illinois. So the court administrator is supposed to put together a list of people who are legal voters, registered voters, have an Illinois driver's license or an Illinois identification card, or is a person with a disability with a state identification card, or has filed a claim for unemployment insurance. So the roster of potential jurors in Illinois is drawn from those registered voters, those with Illinois licenses in the county, or some other Illinois state identification card, or has filed a claim for unemployment insurance. You get paid a paltry sum, but you do get paid. Your employer must give you time off and can't fire you if you take time off to go to a jury, to jury duty. But the employer can collect your jury pay if that person pays you, gives you a paid day off. So in other words, you can't collect twice. Your employer can't give you a paid day off and then you collect from the county. Well, let me rephrase that. You could collect twice. Your employer could give you paid time off and you would collect from the county, but your employer also has the right to take that back from the jury fee, the jury payment back from the county. The state statute provides for hardships as defined this way. If there is a hardship because of your occupation, business affair, physical health, family situation, active duty in the Illinois National Guard, active duty in the Illinois Naval Militia, or other personal affairs. So there are some folks who by statute could be excused for hardship. They would have to show that indeed it is a hardship. Also, a person who is the primary caregiver of someone with a mental or physical disability, a person who's been medically diagnosed as having a behavior problem, or a child under age 12. So if you're the primary caregiver for someone in that situation, you can be excused. Also, if you have a permanent or legal, I'm sorry, let me rephrase that. If you have been found by a court to be unable to take care of your own affairs, or if you have been adjudged as having a permanent or total disability, you could be excused. So some folks like jury duty, some folks don't. It is interesting, as I mentioned previously, that Justice Breyer has said that jury duty is the one time that we participate in direct democracy. So we don't elect someone else to make decisions for us. We are the decider. We sit in the jury box and we make the decision. There is a new video out that the Illinois Supreme Court has out, and I'm going to show you later today how to get to the Illinois Supreme Court website. And if you go to the Illinois Supreme Court website, there is a jury video that I think is very good. So if you have a chance, you might take a look at it. All right, so those are the jurors. Who else do we need? Well, remember way back when you decided that you wanted to hire an attorney. So we need attorneys. I'm going to share with you a little bit about how someone becomes an attorney, because when I share this with folks, they're often surprised. And then I'm going to talk about how you select a juror, a lawyer, And Illinois State Bar Association has out something new, relatively new, that is very helpful in that regard. And then I'm going to talk about how you can deal with lawyers who are not so good. So how does one become a lawyer? Well, in Illinois, you need a college degree. Some states you don't. And then you need to be a graduate of an American Bar Association approved law school. There are 9 law schools in Illinois. They are all ABA approved. That's the body that periodically comes in and accredits a law school after it conducts an investigation. California is notorious for having a whole bunch of law schools that are not ABA approved. And they let people sit for the bar in California under certain other conditions that are rather onerous. But for the most part, you have to graduate from an ABA approved law school. To get into law school, you have to have taken an exam, an LSAT, law school admission test. Law school admission test. Some states are changing and are accepting other, usually the GRE, the graduate record exam. But for the most part, it's the LSAT. Most law schools look at 2 things. They look at your LSAT score and they look at your undergraduate grade point average. They may consider other things, but those are the 2 critical. So then you spend 3 years typically in law school. You might graduate a little early with some summer work. One thing that might surprise you is you do not have to take any kind of a practicum. So doctors, as part of their training, must take internship. They must have a practical experience. Law school, none. I had no practical experience while I was in law school that was part of my curriculum. I worked, so I got practical experience that way, but I did not get any practical experience as part of my curriculum. I could have, I made the choice not to. So one thing that's very interesting is you take a look at a brand new lawyer and that person may never have had a moment's practical experience, or they may have had a lot of practical experience, depends. The law school here, SIU, has enough opportunities that everybody could take a practical course, either an externship where they work for somebody else or a practicum within the law school if they wish to do so. Having graduated from law school, you get to take the bar exam. The bar exam is a 2-day exam. It's offered about 8 weeks after graduation. It's 6 hours a day for 2 days. It covers some 13 topics, depending upon how you count them. And you also have to pass a separate ethics exam. Now, here's something that's sort of interesting. After Watergate, and I think most of you in this audience will remember Watergate, Nixon, the burglars breaking into the Watergate office of the Democratic Party, apparently to try to figure out what the Democrats were up to. Since they were choosing George McGovern, there wasn't a whole lot to worry about, but nevertheless, Nixon was concerned, and there was the break-in of the Democratic headquarters in the Watergate Hotel, Watergate office building, all those many years ago. And there were a lot of lawyers involved, and people kept saying, well, we didn't know that was unethical. Well, we didn't know we shouldn't do that. So law schools and the American Bar Association began to require law schools teach a course in ethics. And now in Illinois, as in many states, you have to pass a separate test on legal ethics. What is interesting is all this exam does is test whether you know the law of ethics, you know what's required of lawyers. It doesn't test whether you are an ethical person. It's simply testing, do you know the rules? But there is a separate exam for lawyers upon graduation in ethics, as well as that 2-day bar exam. Now, that's not enough because we're concerned about lawyers' character and fitness. That's the term we use, character and fitness. Or do you have the ethics, the personal habits, the responsibility, the trustworthiness to be a lawyer. And what we do in Illinois is we ask people, require people to complete a questionnaire of some 50 questions, where we ask them about all their past jobs and were they ever disciplined, were they ever fired, all their past undergraduate and graduate and law school colleges, were they ever disciplined, were they ever accused of plagiarism. We ask for personal references. We ask for we get enough information that we do a criminal check. So for every place they've ever lived or worked for the last, I think it's 25 years, we do a criminal check. We do a police check. Has this person ever been arrested, not convicted, arrested in any of the cities where they lived or worked? We also separately ask if they've ever been arrested, not convicted, arrested. We ask, with the information we have, we do a credit check. So in general, we are very concerned about new attorneys who might have a history of dishonesty, a history of financial irresponsibility. They don't pay their debts. They skip out on their landlords. Might have a history of anything that would cause us to be concerned about their ability to be a responsible attorney, anything that might cause us to worry that they're going to steal clients' money. Often you will hear that someone says, I will not go to counseling while I'm in law school because if I go to counseling, it's going to count against me. As a matter of fact, the opposite is true. We do not ask in Illinois if anyone's had a mental illness. Let me repeat that. In Illinois, we do not ask if you've had a mental illness or if you've been in counseling. But what we do ask is there anything in your history that would cause you an impairment in your ability to practice law? So some states ask about mental health issues. We do not. But we look at the pattern and practice of their conduct, and sometimes that will tell us we're concerned, and we will refer someone to a character and fitness team. Now, I'm going to talk more about this in just a bit, so I'm going to stop there in terms of character and fitness. When someone completes all this, graduates from law school, passes the bar exam, passes the ethics exam, passes a character and fitness review, they have a general license. We do not have specialization in the bar. We do not have board certification in the bar. So when you go to a doctor and a doctor is board certified in cardiology, you're pretty sure that person's an expert in cardiology. Or they're board certified in ophthalmology, they pretty well know more about eyes than anyone else. We do not have that in law. We have a general license. So you could start doing criminal work, you could start doing wills, you could start doing business law with that general license. So let me just pause there for a moment and see if you have any questions about anything I've talked about so far, because I'm about to show some slides about how to find a lawyer. So let me pause and see if there are questions.
Yes, it's bothering me about the blind juror and the ability of that juror to look at evidence that's being presented that you need to look at. Something as simple as a video showing the person running away. How do they know unless somebody tells them?
Good question. Anyone have any thoughts? We have blind judges. And the same question has arisen. If it were a bench trial, that is a trial in front of a judge instead of a juror, would the blind judge be in the same position to assess credibility as a judge who's not blind? Obviously, in a case, Barbara, like you've just talked about, someone's going to have to narrate what was the situation on that video. And I could imagine a situation where a lawyer would excuse that juror, say, because in this case, because of the evidence in this case and the need to study and see and understand the details of how this accident happened, I'm going to excuse this juror because I don't think this juror has the ability. But that I think the lawyer would have to wind up having to use one of the peremptories. The judge is going to first ask about the ability of that juror to see or to be helped in some way with some kind of an accommodation. And if that doesn't work out, I can imagine that the judge might excuse them. But across the board, starting out of the gate, that blind juror is just treated like every other juror. But I think that's an interesting question. I have asked about blind judges in that same regard, and some of you in the audience may have more experience than I do in terms of the various accommodations available and the ways that we all adjust in life to making these determinations. But offhand, I mean, again, out of the gate, starting point, the blind judge is treated like every other, blind juror is treated like every other juror.
Yeah. Well, I was
Any other
thinking,
questions?
oh, go ahead.
Any other questions? All right. Well, I'm going to share with you a question that I get frequently. And I think Dorsey's on here, and I bet Dorsey gets it frequently. And I bet when Dorsey gets it, she's got an in, she can say, yeah, my husband. But I often get the call, here's my situation, I need a lawyer, who can you recommend? And so I'm going to do a little share screening here. The Illinois State Bar Association, ISBA, has a website that it helps the public. And I have to say that it's much better than it used to be. So if you go to the ISBA website and you click on public, it's going to ask you, do you need legal help? Visit Illinois Lawyer Finder. I can't speak this morning, sorry about that. Visit Illinois Lawyer Finder to search our online directory. I'm going to show you that in a minute, or learn how to get a referral. And so then there's information about who are lawyers. What if you can't afford any? What if you're going to do it yourself? And what if you think someone's practicing law when they shouldn't be? So here are some options that are there for you. And one of the options that the Illinois State Bar Association offers is a referral service. So you can go online and say, yes, I am in Carbondale, Illinois, in Jackson County, and I want to get a divorce. Or I am in Jackson County, and I think that I have a business lawsuit and I need somebody who knows business law. Or I've had a car accident and I want a personal injury lawyer. And you can get a 30-minute visit with the lawyer, either in person or by phone, for the minimum, for a guaranteed rate of $25. So 30 minutes, $25. The value of this is in 30 minutes, you can get some information as to whether the lawyer thinks there's a valid claim, and you can make an assessment as to whether or not you think this lawyer is the good person for you. The other advantage is, you're only risking $25. You don't have to hire this lawyer. Two things you should know. I'm 99% sure that you have to be a member of the Illinois State Bar Association to be in part of this service. I am not a member of the Illinois State Bar Association. I used to be. It's a voluntary association. When I retired from the law school, I stopped my membership because it was just one more cost I didn't want to incur. But throughout the years that I was in practice and teaching, I was a member of the Illinois State Bar Association. R.J. Robertson, who's on this, would not be, because he's not an Illinois lawyer. He's a Missouri lawyer. The other thing you should know is that lawyers self-identify their area of concentration. So if I go on here and I say I want a lawyer that does adoption, and the person that I'm referred to might never have done an adoption, but they've said they're willing to try, or they're willing to handle these cases. So those are two cautions. It's only Illinois State Bar members, It's a voluntary association, so it's only people that have chosen to belong to the Illinois State Bar Association, and they have identified for themselves. There's no guarantee here that they are an expert in that field. So that is one opportunity that you would have to try to get some help if you were needing a lawyer. One thing you should always do if you're looking for a lawyer, whether you go through the Illinois State Bar Association Lawyer Referral Service, or you open the phone book, or you call me or Dorsey and you say, hey, who's a good lawyer, is go online to the ARDC Lawyer Search website. ARDC, Attorney Registration and Disciplinary Commission. It is a listing of every lawyer in the state of Illinois. I just told you the Illinois State Bar Association is voluntary. I don't belong to that. But the ARDC is a listing of every lawyer licensed in the state. I am licensed in the state. My license is active. So this is what you would find. You would find my name, any former names, my address, phone number, when I was admitted, so you get a sense of how long I've been out there. What is my registration status? And you see that I am active and authorized to practice law through 2021. If it said inactive, it probably means someone is retired, or for some reason, maybe illness, they're just not practicing. Then you should check, does this person have malpractice insurance? And it says that I don't. In annual registration, the attorney reported that the attorney does not have malpractice insurance. Why not? Because I'm not practicing. I'm not practicing. So I don't carry malpractice insurance. If you want a lawyer who's going to help you, make sure that lawyer has malpractice insurance. Why might they not carry it? Two reasons. One, they can't afford it, in which case I would be very worried about hiring that person. Or two, they just made some choice that I can't understand why they've made that choice. But always check to see if they have malpractice insurance. Next, what is the public record of discipline and pending proceedings? So have I ever been disciplined, or is there a pending proceeding against me for discipline because I have violated the discipline rules governing attorneys, those rules that I learned about and passed that ethics exam about way back when? And no, I have no record of discipline. So that is a very helpful thing to check out. Now, the Illinois State Bar Association also has a lawyer directory. So the first case was a referral. So you go on and you say, I don't know who I want, but I need a family lawyer, I need a business lawyer, I need a divorce lawyer, I need a personal injury lawyer in Jackson County, and it helps you find an attorney. Let's say instead you have somebody in mind and you've just done what I told you to do, which was to check to make sure that they have a current license, they haven't had discipline, they have malpractice insurance. Then you could also ask, go to the Illinois ISBA lawyer directory, and I put in a name, and I'm not going to tell you who it is. I just put in a name for the heck of it. And it tells you that that person's accepting new clients. It tells you that this person wants to get work in these areas: appellate practice, asset protection, that means money, business startups, where he or she went to school. And then these are Illinois State Bar Association sections. Now remember, everybody doesn't have to belong to an Illinois State Bar Association. And if they do, they may not even belong to any section. But when you see that they do belong, it means that they are interested enough in the practice to actually try to stay current, participate with other lawyers in that field, exchange ideas, get up to date on things. And here's a list of areas where this person wants to, has joined a section and is interested in learning more and staying current. And then you see other information, the date of their license and their address and phone number. So that, I think, is a very helpful resource for you if you are looking for an attorney. Just to give you an idea of how many section you could belong to if you're an ISBA member, Illinois State Bar Association member. I'm not going to save this slide for you, but just get an idea. Agriculture, animal law, cannabis law, criminal justice, education, elder law, energy, family law, food law, intellectual property, labor, legal technology, local government, mental health, mineral law, real estate law, traffic, etc. I'm going to do a couple more slides and then I will take some more questions. What if you can't afford a lawyer? Well, again, on the Illinois State Bar Association website, there are links to several groups that can help you. And you see there some groups that will help you, and you see some law school clinics that might help you. What if you have to handle this yourself, or you choose to handle this yourself? The Illinois Supreme Court has started a process of approving certain forms so that if you decide that you want to handle a matter yourself, for example, you want to make a name change. You want to change your name. Well, here's the form to do it. You don't have to figure out, how do I do this? How do I make it so that the court's going to accept it? Here's a court-approved form that you can file, and it will give you instructions on what else you have to do. What if you want to file for child support? This is, again, a court-approved form that you can use. What if you need an interpreter? Here's a form. What if you're asking for a waiver of the fees because you can't afford them? Here's a form. These forms that are court approved don't cover everything, but they are an effort on the part of the court to provide information for people who cannot afford a lawyer or choose not to have a lawyer and need to do it themselves. And here are some standard forms that they can use. I'm going to stop the share. I'm going to come back and take questions and see, do I have any questions so far about anything to do so far with how one becomes a lawyer or how one selects a lawyer? Because I get this question a lot. Well, I hope that being able to check the lawyer search function to make sure the person has insurance, has an active license, has not had prior discipline is of help to you, along with that directory that tells you a little bit about areas of interest. I said that we do not have specialization or board certification or something akin to what the medical field has. But you will see, and if you open the phone book, the good old-fashioned way in the good old-fashioned days when you used to get those phone books, and you go to the lawyer page, and you will see categories. So there can be a category called wills, probate, and you'll see lawyers listed. Or there'll be a category called personal injury, and you'll see lawyers listed. Lawyers have chosen to identify themselves as that area. They are not officially certified or given any indication of specialization. Now, once in a while, you'll see something that says certified. I want you to understand what that means. I could decide that I'm going to create a certification for lawyers who work with animals. Those of you that know me know that I'm not an animal fan, but let's say I decide, because I want to make some money, that I'm going to create a certification for lawyers who work with animals. And so I will create some course that lawyers have to take online, and I will give them some test. And at the end of which I will give them a really nice, big, fancy certificate that says you are now a certified animal lawyer. And it will be from the Schmitz School of Animal Law. That's how good it is. Okay. So every once in a while, you'll see that people have certifications. They do. And it might be from somebody really good, and it might be from the Schmitz School of Animal Law. So just understand that we don't have the kind of board certification that you see in medicine. I have received a question that is, To call oneself an attorney, do you need to pass the bar exam or is graduate from a law school sufficient? Well, actually, the word attorney means to stand for someone else. And if you have done a healthcare form, if you filled out one of those forms that says, in case of my incompetence, I want my spouse, my mother, my child, my next door neighbor to make decisions for me, you've made that person an attorney, not an attorney at law, but an attorney. So do you need to pass the bar exam or graduate from law school? A law school graduate, as I understand the term, is a lawyer. To be an attorney at law, you need to be practicing and have clients. That is my understanding of the terms, but in the real world, we use them interchangeably. Is there any lobbying group or political group or political interest in creating specialties? Do you think there should be certification? Well, in the perfect world, I would like to see certification, but here's the real world we live in. In Pulaski County, 2 counties south of us, there are 5 attorneys, 5. One's a judge, one's a prosecutor, one's a public defender. That leaves 2 people, and I suspect one of those is retired. That means one person is probably available for real estate advice, criminal advice, driver's license, wills, divorces. So if we were to create a specialty, a certification, we would probably say that you need to have 25% of your practice in this field. And you need to take these courses and keep up to date. And you need to show enough experience in this field that we can call you a specialist. Well, how does somebody in Pulaski County or Pope County or Johnson County, or let's go east, Gallatin County, White County, Edwards County, I'm purposely picking on some of these very small counties. How would you ever have enough experience in one field? And let's flip the coin. You'd have to turn away business in order for things like a will or a traffic issue or a juvenile issue, in order to concentrate on family, which is the area that you want to have the certification in. So yes, I would love to see a certification, but it would be very hard to do in Southern Illinois. Last Saturday, I drove through Mound City. Mound City is the county seat of Pulaski County. There are 600 people in Mound City. Somebody has to be a lawyer in Mound City, but that somebody has to do all of the above. And I just don't see how you work out a specialization program for counties in what some people call the forgotten areas of the state, the 4 western counties, the 4 eastern counties, and the southern counties. In Springfield, you could have it. Champaign, Decatur, you could probably have it. Rockford, you certainly could. Metro East, you probably could. I just don't see it here, even though I would love it. Maybe somebody smarter than I can come up with some other way. Now, this does remind me, though, to tell you that in Illinois, as in I think almost every state now, there is a continuing education requirement. Up until just a few years ago, you could have graduated from law school with the knowledge of wills that you had in 1985 and still have that same knowledge and not update it. And there was no requirement that you update it. We just hoped that you had the goodwill to do it. Several years ago, the Illinois Supreme Court put in a requirement that lawyers have continuing education. You would have thought that the Supreme Court required that lawyers line up on Route 13 in the middle of the median at midnight and do physical exercise for all the hue and cry that came about from that. By this time, we've pretty well gotten used to the fact that every 2 years, I have to report that I have had 30 hours of continuing education. Lawyers resisted this initially. I think they've gotten used to it. It can be in any area for the most part, but of those 30 hours, 2 have to be in legal ethics, 2 have to be in mental health related issues, including self-care kinds of issues, and 2 have to be in diversity related issues, and I'm probably forgetting something, but I'm pretty close. Later this week, I'm going to attend the American Bar Association program on elder law by Zoom, and I'm going to get about 8 of my 30 hours in the next during this week. Could I turn on the Zoom and go do my dishes, bake my cupcakes, whatever? Well, not if it's an American Bar Association, because every few minutes it asks a question and I have to answer it. So I have to at least stay somewhat alert. Some of the programs I've taken over the last couple of years on Zoom have been excellent. One was so bad that I did clean out all of my mail during it. I will confess to that. So that's 3 hours that or 1 hour that I probably didn't officially earn. But since I was over my 30 hours, I think I'm okay. Another question, do you have to prove inability to pay in order to get help? For that lawyer referral service, no, anybody can call in. For other kind of help, yes. Land of Lincoln, for example, there would be some requirement for how much money you earn in order to take advantage of Land of Lincoln services. Now, remember that while the U.S. Supreme Court has said that we are all entitled to legal advice, legal assistance in criminal matters, that means felonies where the sentence is a year or more, there is no right to an attorney in a civil matter. So if somebody is suing you, there is no right to an attorney. It's your job to get an attorney and to find a way to get that legal help if you need it. So some of the programs, yes, there's a requirement. The Illinois or the SIU Legal Clinic has no financial limit. And the reason for that is because it is, they get money from the U.S. Department, I'm sorry, I'm getting the names mixed up. The Agency on Aging, they get money from the Area Agency on Aging, and that is not needs required. Is there any way to get a list of references from past clients? Sure, just ask. And that's a question I would ask. And in that 30 minutes, I would ask, how many adoptions have you handled? Are there some clients that would be willing to share that? Now, the attorney-client relationship is confidential. I have always maintained that the fact that I have an attorney is not confidential. What I've said to the attorney is confidential. There are people that claim that even the reality of an attorney-client relationship is confidential. I don't think it is. So I think you could ask. Now, the lawyer should not give out a name without the client's permission. So if I said to my attorney, how many adoptions have you handled? Could you give me the names of some people that you represented? I would hope the attorney would get permission from the client to give out that information before he or she did it. Any other questions? Well, I'm going to keep going this morning because I'm at a point where I don't want to stop. So if you need to excuse yourself, many of you have shut off your video, so I won't know that you're excusing yourself anyway, but if you need to excuse yourself from the video, you just do it. A little more about attorneys. Not much more, but just a little more. I frequently get a phone call that says, and often it goes like this. My mother died in fill in the blank, some other state. And her lawyer who prepared her will was so-and-so. And that lawyer, I hired that lawyer and it's taking forever and nothing's happening. And he or she won't return my phone calls. What can I do? Can I fire the attorney? Bottom line, yes, you can fire the attorney. Also, bottom line, you don't have to hire that attorney to begin with. So just because attorney X did your mother's will in Colorado, you did not have to hire that attorney to handle it. I recommend that you do for the most part. And here's why. Local attorneys have insights as to how the local banks, the local stockbrokers, the local title companies, all those other entities that you wind up having to deal with to sell the house or or cash out the stock or transfer the money. They know locally how the people want it done. And I think it's a smart idea to use that person, but you don't have to. And what if you chose to and that person's just not doing anything? One of the most constant complaints to disciplinary authorities about lawyers is that they don't return phone calls. I don't know why that is. I suspect a couple things. One, I suspect it's because they get tired of telling you the same thing, which is, it's moving along. I know it's slow, but it's moving along. Don't worry about it. In some cases, maybe they aren't doing the job as well as they should be. And maybe they just don't want to try explaining that to you. Before you fire the attorney, here's what I would do. I would write a letter, and I'd write 2 letters. The first letter I'd write is the one I really want to write with all the snide comments and all that sort of thing, and then hit delete. And then I would write a second letter. I'd print out the first letter and crumple it up and throw it in the wastebasket because that makes me feel good. I've done that before. I've written a letter that I want to send with all the snide comments and sarcasm that I want in it, and that I've printed it out, crunch it up really well, throw it away, and I feel better. Then I write the letter I'm going to send. And I'd say, dear attorney, here's who I am. Here's the matter you're handling. Here's the last time we communicated with each other. I'm concerned about whatever. Please get in touch with me. And I provide any number of ways to get in touch. I would make it a letter, not a text, not a email. Certified if you want. I don't know that you need that. And give them a deadline to get back to you. I think that is step number 1. Now, what if you've done all that and it's just not working? You want to fire them. Yeah, fire them. But understand that the next attorney who's going to start over, and you're going to pay for a lot of work that's already been done because the new attorney is going to have to review it. Understand that you own that file, you own that work of the attorney you don't like, and that attorney needs to transfer it, but understand nothing's going to take place overnight and there's going to be cost. How do you report a bad attorney? Somebody wants to know. Well, you go to the ARDC, the Attorney Registration and Disciplinary Commission. That is what we call it in Illinois. It may go by other names in other states. And so how would you find it? What I would do is I would go to the Supreme Court website for each state. And I find that's a pretty easy thing. If I type in Ohio Supreme Court, Google or whichever browser magician is going to probably take me to that. I would then look for some link for how to report attorneys. It might be through the court, it might be a separate agency. In Illinois, we have a separate agency, the Attorney Registration and Disciplinary Commission. There's limits on what matters they take. The fact that it's a fee dispute is probably not a disciplinary matter unless it's indication of theft. Sometimes they will investigate. Sometimes nothing will happen, but probably the very fact that they investigated might very well get your attorney moving. So you can do that, but I would not do that until I had written a letter telling the attorney why I'm unhappy. Couple of questions. Forms to write wills are available online. Are they any good? No, do not use them. Do not, please, please, please do not use those online wills forms. Do not use those online divorce forms unless it's an Illinois Supreme Court approved form. You don't want to mess up your future retirement plans. You do not want to mess up your kids' wills, financial situation by some online things. There are attorneys in town who do estate work who will tell you they make a lot of money cleaning up after a form that somebody got offline. So please do not use that. If you want attorneys who would be good for wills, call me, call RJ, call Dorsey Prosser, call one of us. Please do not use those online. Are executors of wills required to provide accounting of funds? Yes, in Illinois they would, and I assume in every state they would. So I have a will and I leave $500 to the International Cat Society, and I leave $500 to my church, and I leave $500 to the Arts Council of Illinois, and I leave some money to this relative and some money to another relative, and my house has to get sold and distributed to my family. Yes, all that has to be reported to the court, and the court has to see enough detail that it can know that the executor did not put any money in the pocket. I don't know of any state that would not require that. I suppose there might be some. I don't know of any. Certainly in Illinois would be required. One last thought on attorneys, and I will move on. The Illinois Supreme Court has created something called the Client Protection Program. Now, I told you earlier that I do not belong to the Illinois State Bar Association, but I am licensed. And in order to be licensed, I pay the Illinois Attorney Registration and Disciplinary Commission some money every year. I think it's in the range of $400. I forget what it is, but it's around that. $25 of that amount of money that I pay every year goes to something called the Client Protection Program. And if an attorney harms you financially, you might have a claim that you can file with the Client Protection Program run by the Illinois Supreme Court and get some money. Now, if the attorney malpracticed, the attorney goofed in some way, you sue the attorney and you get money that way. But if the attorney stole your money, and that's the most common issue here, the attorney stole your money. I know it happens, it does happen. If the attorney stole your money, you can seek money from the Illinois Client Protection Program. And according to this report in 2020, I pulled this off the court's website in the last couple of days. They paid out, looking for the amount of money. Oh, they paid out $1 million, over $1 million, $1,094,000 on 81 claims against 18 lawyers. So the good news is there were only 18 lawyers. 81 claims, so apparently some of those 18 lawyers stole money from more than one person. The amounts range from $100,000 to top amount down to $10,000. This fund can then go after the attorney to try to get reimbursement from the attorney who did the stealing. Now, the problem is if the attorney did the stealing, the attorney probably is not going to reimburse, but it could happen. So there is some protection. Currently, you will be shocked by what I'm about to tell you. Currently, there are 65,000 attorneys in Illinois. 65,000 attorneys in Illinois. 87% of those lawyers are in Cook or the Collier counties. 87% of all Illinois lawyers are in Cook, DuPage, Kane, Lake, McHenry, and Will. And as I said before, we've got counties with 5 attorneys. You probably know the George Earls story. George Earls was from Elgin, up near Chicago. He wanted to be a judge, and he knew he'd never be a judge up there. It would take forever. So he moved to Pulaski County because people have to move into Pulaski County to run for state's attorney or to run for judge. And so within a few years of graduating from law school, he was a judge. And going back to that specialization question, in any given day, he would have done an adoption in the morning, followed by a sentencing of a criminal, followed by a major report on an estate. And after lunch, he would have tried somebody or done a traffic case. So specialization of judges is not something we have in Illinois either. And that brings me to the last group of people we need, who are judges. Judges in Illinois, as you know, are elected. They are no smarter or better educated than any other lawyer unless they choose to be, or unless they happen to be. So I could run for judge because I'm an Illinois lawyer and I live in the county where I'm going to run. I don't need any other particular credential other than being elected. Our Supreme Court justices are elected for 10 years, appellate justices for 10 years, and our local trial judges or circuit judges are elected for 6 years. The associate judges are appointed by the Illinois circuit judges for that circuit, and they are appointed for 4 years and then renewed. And let me share a screen again. Just to, again, keep you up to date with your local public officials. In the First Circuit for Jackson County, the presiding judge, who must be a circuit judge, is Christy Silverson. The other circuit judges, these are the people elected for a 6-year term, are Chuck Grace and Steve Bost. The associate judges, they're appointed for 4 years by the judges, Ralph Bloodworth, Ella York, and Michael Fiello. In our neighboring county, Williamson, the circuit judge is Stephen Green. The other circuit judges are Amanda Biasi-Gott, Carrie Gill, and John Sanders, and the associate judges are Jeff Goffin and Michelle Schaefer. Now, as I said, no special requirements other than being a lawyer. They do, however, soon after being appointed, attend what they fondly call baby judge school, meaning that right after they are appointed judge or elected judge, they do attend I think it's a 2-week school for new judges. There is a mentor program for new judges, so a more senior judge mentors them. There is an evaluation program that they can participate in that helps them. And just like I have to do 30 hours of continuing education every 2 years, they attend Illinois Judicial College, where they stay up to date on various issues. There are limits on what judges can do. And with regard to a trial like we've talked about, the civil trial, they have to recuse themselves if they or their spouse would have an economic interest in the matter, would know the people involved, or would know the lawyers. You may have seen a news item in the last few weeks that 160 judges, and these were federal judges, 160 federal judges were found to have an economic interest in a case that they judged, and they did not disclose this. Now, those are federal judges, but the same requirement. Those 160 judges are in violation of the rule that they have to recuse themselves, or at least disclose their economic interest. Now, there are times when the attorneys will waive that and say, that's okay, judge, we trust you anyway, but it has to be disclosed. And in some cases, they really have to recuse themselves. So they are not supposed to hear matters where they know you, they know one of the parties, they know the attorneys, or they have an economic interest. Shortly after Judge Riona Daly became a magistrate judge in U.S. District Court in Benton, I went up to say hello and to visit with her and one of her law clerks. I had not taught Riona Daly, but I knew Riona as a student, and I knew her law clerk and had taught her law clerk. And we were going to lunch. And as we're going to lunch, I said, can I buy lunch? And both of them said simultaneously, no. And it was very clear that they did not want any hint that I would do anything to influence them. They did not. They must file an economic statement every year, by the way, reporting any gifts or other payments that they've received. For example, if they go out and give speeches. And I think that they did not want to say that they had to report a $12 lunch bought by Suzanne Schmitz. Now, I want to tell you about something that I'm willing to bet you don't know anything about, and I personally find very interesting. So I'm going to share it. Judges and lawyers do a lot of work that you don't see. They serve on a lot of commissions and committees. And here are a few of the committees that the Illinois Supreme Court has that are made up of lawyers and judges who, by the way, get no payment for this. So these that I'm showing you right now all relate to lawyers. One of the things I should have said earlier, if you are a pesticide inspector, if you are a barber, if you're a real estate agent, your license is governed by the Illinois Department of Professional Responsibility. But if you're a lawyer, your admission, your discipline, your registration, and your disbarment is governed by the Illinois Supreme Court. So we have a committee on board of admissions to the bar. We have a committee on character and fitness, professional responsibility for lawyers, a LAP program. This is a lawyer's assistance program for lawyers who have issues with impairments, such as mental health issues, gambling, drinking, that sort of thing. A lawyer's trust fund, where the lawyers put money that belongs to your clients. This ARDC group that I've just been talking about, this continuing education program, and so on. So these are some of the committees that the Illinois Supreme Court has made up by lawyers and judges that oversee lawyers. Show you one more. There are three of them for judges: the Judicial Conference, which is the education program, the mentor program, and the performance evaluation committee. So those are committees that oversee and work with judges. Now, I'm going to show you the Board of Admissions. So this is the board that oversees the admissions process to become a lawyer in the state of Illinois. And you will see that I'm on there. There are 7 of us. Each one of us is appointed by a justice of the Illinois Supreme Court. So Rita Novak, Arlene Coleman, Andy Rauchi are from Chicago. Randy Johnson's from one of the suburban counties. Brian Towns from LaSalle area. Peggy Ryan, who by the way is an SIU graduate, is from Springfield, and I'm from the southern part of the state. As you can see, we have short terms. We oversee the bar exam, and we oversee admission to the bar. We don't oversee the character and fitness portion. That's another group of people. And Don Prosser, for years, Don served on that. Again, all this is done without any extra time off our duties and without any fee. So yesterday I was on an hour-long phone call for this board. And last week I was on a 3-hour phone call for this board. And in November, we will have our regular meeting. So we have a lot of work to do that is not paid. This is the Judicial College. They provide programs for the judges, but the circuit clerks, the probation officers, the trial court administrators, these are often lay people that help the court run. There's a committee on jury instructions. In criminal cases, John Urbis, some of you know from the SIU Clinic on Elderly. John has served on that for years. These are all committees that do work to see that the system of justice in Illinois works and continually works for improvement, and still more. The Illinois Supreme Court of Illinois Rules Committee, Keith Byler has been the reporter on that for years and years. So many lawyers from the southern part of the state have served on these committees. I just want you to see them to have some appreciation for what goes on with keeping the courts running, trying to get them improved, and not. And we do this as volunteers. Should judges be elected or appointed? Well, I am a big believer that they should be appointed, that the election system does not work for judges, that you don't adequately, you're not in a position to make a good judgment as to whether the person should be elected a judge. And the whole idea of campaigning and getting money to run for office, I find distasteful for judges. Having said that, there are at least two things that are criticisms. One, there will never be You will never take politics out of the selection of judges. So Missouri has an appointment process. In Missouri, the governor appoints. People don't vote. Well, that's great, but here's how it works. Governor has committees throughout the state because the governor can't know every judge throughout or every would-be judge throughout the state of Missouri. So there are committees, and the committees interview people that want to be judges and make recommendations. Well, here's the problem with that. I'm the governor. I want more women on the bench. I'm going to appoint committee members who will look for women. I'm the governor. I'm very conservative. I want conservatives on the bench. I'm going to appoint committee members who are conservative, et cetera. You get the point. So it's never going to be pure. I think it's better because I think you get the whole campaigning and money out of it. You don't get politics out of it, in my view. Here's the other criticism that you need to be aware of. And a very good friend of mine points this out. Blacks have been elected judge in Illinois because of an election system. In the early days, a black person was able to get enough votes in Illinois to be elected a judge. Probably would never have been appointed a judge in those days. Not so much today, but in those early days. Women, some people believe the same thing. So there are folks who say that they would never have been appointed to a judicial position because of their background or their lack of connections, but they could have been elected. So you've heard my view, you've heard a criticism. We don't live in a perfect world. Surely judges would know lots of attorneys, sure. And the fact that the judge knows me is not a disqualifying issue. The fact that we are socialized together, we have dinner together every week, we play golf together in between, we do lots of activities. Yes, that might be a reason to disqualify. Okay, other questions? All right, one last thing I want to talk about today. So we have done our jury trial. We have looked at all the players in our civil jury trial. And everything we've talked about so far dealt with a jury and dealt with something that we lawyers call a legal matter, a matter of law. I want to take just a minute and talk about equity. EQUITY. And let me start this way. R.J. Robertson, you may know, has cats. He really likes cats. So R.J. heard about this new dog park in Carbondale. And he said, gosh, if they're going to have a dog park, there ought to be a cat park. There ought to be equality for pets, and a cat ought to be equal to a dog. So if we got a dog park, let's have a cat park. So he goes to the Carbondale Park District and they say, are you kidding? And they laugh him out of the room. Well, RJ's not easily deterred. So he decides to organize a march. And there's going to be a march down Route 13 around Town Square. So he goes to City Hall and he says, I want to have a march. I need a permit for a march. I want you to close down Route 13. We're going to march around Town Square. And they say, no way am I giving you a permit to march. I don't care the cause. You're not blocking traffic. Well, again, RJ's not one to be deterred. He says, wait a minute. I read the Constitution. I have a First Amendment right of speech. I have the First Amendment right of petition. I have the First Amendment right of assembly. And look at that. He's holding up the Constitution of the United States for all of us to see. So he's a smart lawyer. He's going to file a lawsuit. And he's going to file it in Jackson County rather than federal court, just because it's easier for my example here. Well, he doesn't want damages. He doesn't want money. He doesn't want them to stop his march and sometime later, a year from now, he gets some money because they violated his rights. He wants to march, and he wants to march now. So he is going to file an injunction action. He's going to file a lawsuit in Jackson County that's going to do two things. He's going to ask for a declaration that his rights have been violated and an injunction stopping the city from stopping him. He wants an order to the city, give RJ a permit for this march. He is appealing not to law, but to equity. Once again, we go back to England, Middle Ages. As the court system evolved in England, there became all these rules and regulations for how you filed a lawsuit. And it was very strict. And frequently what you or I wanted didn't fit into one of those. So people began petitioning the king, give me justice. I know I can't get it from the court of law because I don't fit that pattern, but give me justice. Give me equity, give me fairness. And as things evolved, there became courts of equity or courts of chancery. And as we moved into this country, we kept that basic system. So if you look at the Illinois Constitution, the US Constitution, Article 3, it talks about courts of law and equity. We used to have in the United States and in Illinois, two court systems, law and equity. It got combined. Now RJ can go to Jackson County. It makes no difference what judge he goes to. They have the powers of law and of equity. But when you're filing an equitable lawsuit, you don't have a jury. You don't have all of those rules that I talked about before. Most of them, yes, but not all of them. You're not going to get money. You're going to get an order. Somebody's going to get ordered to do something. Let me give you two other examples. Let's pretend that I own a Picasso. I don't, but let's pretend I do. And let's pretend that Picasso is worth $1 million. If I owned a Picasso, it would not be worth $1 million, but I don't know when to begin with. And let's say that in my will, I donate that $1 million Picasso to the SIU School of Art, because I'm a big believer in the arts. Well, before anyone can come in and probate my will and take care of things and get that Picasso delivered to the School of Art, my brother comes in and takes it. So my brother now has the Picasso that's worth $1 million. And if he's smart, he's got it hidden away somewhere. Well, the School of Art says, whoa, 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 whoa. We could sue him for $1 million and get the $1 million. Okay, so we're compensated for our loss. But, you know, there's other aspects of this loss. I mean, being able to say that we are the School of Art with a Picasso, that's pretty good stuff. Being able to say that we're a School of Art where Schmitz so thought of us and thought so highly of us that she gave us $1 million Picasso, that's good for our reputation. That we are not going to be able to get compensated. So before Suzanne's brother can sell that Picasso, we want an order stopping him from doing that. And we want an order requiring him to give that Picasso to the school. A court of law cannot do that. Would only give him money, damages. A court of equity can give the School of Art an order. One last example. Suppose that I'm a developer. I'm in the real estate field. And I want to build some commercial development. And I have found the best location in town. But there's some problem with it. And I make a contract with somebody. I make the contract with Dennis Leitner to buy his property so that I can build my great development. And then Dennis somehow comes up with some cockamamie idea that he can get out of the contract and he's not going to live up to it. Well, I want that piece of land. I don't want money damages later because it's going to stop me from working on my development. Now, I want that piece of land. So I could get an order saying, Dennis, you've got to carry out the contract. You've got to give her that piece of property. So periodically, there are times when money damages won't do. I want a specific order. Give me the permit for my march. I want an injunction. Union, you can't strike. I want an order saying, give me that land. And that I'm going to go to a court of equity. When I go to a court of equity, I'm just going to the judge. I'm not going to a jury. I'm asking for a specific type of relief that money won't take care of. Now, I thought that I might be able to help you out understanding what that term equity means, but I see from one of the questions I didn't. So let me give it some more thought for next week and see if there are any other questions, and maybe I can straighten it out. I just want you to know that when you see the words law and equity, equitable courts, which same courthouse as the law courts, are not going to give you money damages. They're going to give you orders. Whereas a court of law is going to give you money damages. Court of law is what we would bet in, but there are civil jury trial. There's a jury. A court of equity, where you're appealing to the court to order somebody to do the right thing, that is going to not be a court of law. That's going to be a court of equity, and no jury, just a judge. Other questions? Well, let me tell you what we've done in 4 weeks. We had a car accident. We decided that we wanted to get some relief. We wanted to get some damages. We wanted our harm compensated. And we figured out that the common law way back in England in the 1200s created a system by which we could do that. It's called the common law system. That there were judge-made law that existed long before there were legislative bodies that would allow us to go to court and get relief. And we found out that it was called a tort, T-O-R-T. And we decided that we were going to proceed, and we were going to hire an attorney and not handle it ourselves. We decided that the place where we were going to file this lawsuit was Jackson County, because that's where venue was. And we figured out that a tort required that there be a duty to drive carefully, to act as a reasonably prudent person. That's the legal term we use. In tort, your duty is to act as a reasonably prudent person would under the circumstances, which means that you don't enter intersections when there is another car. So we figured out that there was a duty and that it had been breached because the other guy entered that intersection. We figured out that fact that he entered the intersection when it was unsafe to do so caused us damages, and that we had damages. So we filed that lawsuit, as I said. We filed it in Jackson County. We did some discovery, exchanged information between the two sides so they could be ready for trial. We chose a jury trial. We went to trial. We did opening opening statement. We put on some evidence, and we had a little quiz as to what some of the evidence might be. We did a closing statement. We got a jury verdict. We talked about how that verdict would be divided up, including reimbursing the various people that had paid expenses earlier. Some of it to the attorney, the amount that remained to you, the person who got harmed. We looked at how, if it went on appeal, it would be reviewed by a panel of 3 on the record. There would be no new evidence taken. We concluded that we could not go to the U.S. Supreme Court with our case because there was no federal issue involved. This was a common law issue, a state issue. And that ended the case. We took home $100,000, if I remember correctly. Only a third of which we decided in the end probably went to you. And we asked a lot of questions along the way about why a jury, why evidence rules, why any of these rules. And today we looked at the various players that are necessary to make all this work. Next week, we're going to look at alternatives to this system. We're going to revisit those two quotes that I told you in the beginning. Is the purpose of a justice system to resolve disputes as quickly as possible with the least amount of cost? Or is the purpose of a legal system to give effect to the values of our Constitution? So 2 things next week so far, alternatives and those two, a little philosophy about what's the purpose of the justice system. In order to get ready for next week, I want you to think about this question. What percent of all cases that get filed in court do you think go to trial? So think about all the cases that get filed in court: criminal, civil, federal court, state court, the whole mess of them. How many of those do you think actually go to trial? Not get filed. We said they've been filed. How many of them do you think go to trial? I will give you the answer next week. And one last thing about next week, if you've had a chance to watch the movie Worth, that will be part of our discussion about alternatives to the civil justice system as well. Okay, I see. So that's next week. And the other thing I will do between now and next week is I will take selected slides from today and send them off to you next week. Now, a couple questions. Is there a license for lawyers that must be renewed every year? Yes, ma'am. Every November, I get a bill from the Illinois ARDC, Attorney Registration and Disciplinary Commission, telling me how much I owe and asking me several questions, one of which is, do I have insurance? And I file that report and send it in and send in my money, all of which is done electronically now. And then I get a little card. I get a card about this size, very small, that I could always show at the courthouse. That is the proof that my license is good. How many lawyers are there in Jackson County? I can tell you exactly. As of 2020, there were in Jackson County 190 lawyers, 190. Now, there are not 190 lawyers in Jackson County who are practicing attorneys. Think about how many lawyers there are at the law school. Think about how many lawyers there are at other colleges within the university who do not practice but have a law degree in criminal justice, in political science, in business, and so on. There are many lawyers that live in Jackson County who go to Mount Vernon, to the appellate court and work, or go to the federal courthouse in Benton. And then there are lawyers in Jackson County who are practicing. So I cannot tell you how many of these 190 lawyers that are registered with the ARDC have an active license in Illinois, or did in 2020, how many of them are actually practicing lawyers in Jackson County, but a lot. There is a chart that I'm looking at called, it's part of the annual report from the ARDC. I'm one of those few people that probably go to websites and go to publications and look for reports of this sort. And I actually read these, and it's amazing what I find. Friends of mine make fun of me for doing this, but I find it interesting. So if you look at downstate counties, Alexander, which is Cairo, there are 7 lawyers. Massac County, which is Metropolis, where the boat is, 16 lawyers. Polk County, where they say there are more deer than people, 6 lawyers. Pulaski, 4. I think I said 5 before, 4. Johnson County, just below us, Vienna, there are 10 lawyers. Union County, just south of us, there are 27 lawyers. a couple of whom at least are going to be working at Schultz Mental Health Center and not be in the practice of law. So for many of these counties, there are only a handful of downstate lawyers. Jackson County is going to be a lot like Champaign. Champaign County has 525 lawyers. Well, think of how many of those are at the law school at U of I or in other positions at the university. So when I give you that figure for Jackson County, you have to keep in mind that many of those lawyers are not practicing. Williamson County, there's 140 lawyers. Again, many of those are going to be either at the university here, at John A. Logan as teachers, or working in federal courthouse at Benton, or the appellate courthouse in Mount Vernon. Okay. I will see if I can do any better on equity for next time, since I see that there's still a question on that, and I'll see if I can figure that out, and I'll get the 7th Amendment. I was wrong about that. Thanks to RJ for reminding me of, I will get that straightened out for next week as well. I might just send you an email on that. All right, then we are done. Again, for next week, remember your job, your assignment. Your assignment is, look at those 2 quotes. What's the purpose of our justice system? Your assignment is, what % of all the cases filed in the United States in court do you think go to trial? And if you have a chance, look at those 2 quotes and see what you think is the purpose of our justice system. And we'll try to sort all that out next week. All right, see you then. Thank you.
Thank you, Suzanne.